All right, there we go. Thanks for your patience. It's guess still early to work the technology. So welcome and thanks for joining us. My name's Shawn Smith. I'm a strata property lawyer. I've been practicing for over 25 years now, and we're going to talk to you this morning about dealing with noise complaints. So just a little bit about who the firm is. Cleveland Doan is a full service law firm, but we have a special focus on strata property. About half of the lawyers at the firm work in that area, doing everything from collections, bylaw packages, bylaw enforcement, and dealing with noise issues, which is one of probably the most difficult things to deal with in a strata setting. It's also always the reason I said my family could never have lived in a strata. I couldn't afford the fines that we would have incurred. So we are by ourselves. What we're going to talk about today is a few things related to noise. It's a fairly high level overview because some of these topics you could probably spend a full hour on just on that topic itself. So I'm going to take us through just some sample noise bylaws, sort of understanding the context in which we enforce these noise issues. Talk about the law of nuisance. Talk a little bit about what is unreasonable noise. Touch briefly on flooring. That's one of those topics that could probably, in and of itself, be a seminar. Also talk about the duty to investigate and what that looks like, because that's a central part of all of these noise complaint cases when you read them at the CRT, is what the strata did and whether it did it right. Talking also about proving unreasonable noise exists. So what do you need if you're the strata enforcing a bylaw, or you're an owner who is complaining that the strata is not enforcing a bylaw? What do you need to prove your case? And then touching a little bit on remedies. Uh, so some of the typical noise complaints that we see, and that also you see if you read through the CRT decisions, are music and television, yelling, talking loudly, sometimes barking dogs, flooring-based noise. So a lot of them are complaints, walking, thumping, dragging sounds that are coming down from a unit above. And then sometimes you also get complaints about equipment, so heat pumps or HVACs. If you're sharing a building with mixed commercial and residential, there can often be issues that arise from the commercial operations. And as we go through, we're going to look at a couple cases. There's a plethora of them out there, so it was really hard to choose what ones to talk about. But a couple, we'll use a couple examples as we go through. Going to start just reviewing noise bylaws, because the basis for dealing with noise complaints is the bylaws. Is there a bylaw that prohibits the activity that's being complained about? And if you're going to enforce a noise bylaw complaint or investigate a noise bylaw complaint, you're doing that within the context of the bylaws. So the standard bylaws under the Strata Property Act, bylaw 3 sub 1, addresses that in three different ways. Owner must not use the strata lot of the common property in a way that causes a nuisance, causes unreasonable noise, or unreasonably interferes with the rights of other persons to use or enjoy the common property in the strata lot. Those three are all very similar, but there are some differences. Those are the usual bylaws that you're going to encounter with noise complaints. And most stratas either have those just as the standard bylaws or some sort of variation of them. Some stratas also like to enact quiet hours. So here's a couple examples of bylaws that deal with that. What I always view as important with respect to quiet hours bylaws is not only, of course, obviously the time frame, but a little bit of an explanation of what quiet hours means, because that may not be the same to everyone, and that may create some enforceability issues. So in the top one, the bylaw says a lesser level of noise than expected than outside those hours. So something that may be acceptable at 2 o'clock in the afternoon would not be acceptable at 2 o'clock in the morning. This is a bylaw that I see quite often, or see a variation of it, requiring residents to take steps to limit noise, such as ensuring they don't use hard shoes or covering flooring with soft carpet. There's always some issues with whether or not that's actually effective. I guess I'm getting cynical, and I kind of figure you could. 60% of the flooring could be under the couch, under the bed, and under the table. Not going to actually help on the walking areas. So that's something to think about if you're looking at that sort of a noise bylaw. Some other examples that I came across were ones that set some very sort of strict standards or more specific standards to sound from music systems that can be heard or deemed to be unreasonable. And the bottom one was kind of interesting, talked about if it's for more than 60 seconds between particular hours, then it's deemed to be unreasonable. Bylaws like that certainly help from clarity as to what is or isn't, but there's also the flip side of that is if it falls outside of that, then it's not going to be unreasonable, and there's nothing the strata could really do to enforce that. So thought is always needs to be given when you're drafting bylaws that deal with noise, as well as when you're going to enforce them. We'll start by talking about nuisance, because as you saw in bylaw 3 sub 1, that's a term that's used. It's actually a term that arises from the common law. There's a long history of case law dealing with the law of nuisance long before the concept of stratas came into existence. I remember studying in law school cases about nuisance and cricket, and people complaining about cricket balls flying into their backyards. And you could always tell when reading the case whether the judge was a cricket player or not when they decided whether it was a nuisance. In the strata context, the case law, the Triple P Enterprises case, says that nuisance is a substantial, non-trivial, and unreasonable interference with an owner's use and enjoyment of their property. And that's not very different from the common law view of it, but I quoted that just because it is a case that deals specifically with strata. The general parameters with respect to nuisance are that it must be continuing or repeated. And this is a distinction between nuisance and unreasonable noise. So, unreasonable noise could be something that happens just once. In order for something to be a nuisance, it has to be continuing or repeated. It also has to be intolerable to an ordinary person. And as we go through some of these examples and just discuss proving nuisance, you'll see that we're really looking at things from an objective standpoint, not subjective either from the person who's alleged to be making the noise or the person who is complaining about the noise. And it must be substantial and far beyond mere inconvenience or minor discomfort. And the common law doesn't have things rise to the level of nuisance just because you're bothered by them. It has to be in a substantial interference with the use of your property. Uh, the question to be asked is would it be tolerated by the ordinary occupier? So, if you took the average person, reasonable person from the street, brought them in and put them into that circumstance, would they find what's being complained about to be objectionable? The common law also talks about consideration of the character of the neighborhood. So again, when those cases arose, we were talking about, or the courts were talking about, is this a residential area? Is it an industrial neighborhood? Is it rural? All of those factors come into play. That also carries over into the strata context because we're all living close to each other, next to each other, above and below each other. That factors into the analysis in terms of the character of the neighborhood. We'll move now to unreasonable noise. And as I've said, the two are very similar, but frequency is the main difference. However, they're assessed very much in the same manner. And so I've cited the Chan decision below. Unreasonable noise is assessed applying the principles from the law of nuisance. So the analysis is almost identical between the two. And again, the test is objective, measured with reference to the reasonable person occupying the premises, i.e., the strata lot. So, what would a reasonable person who you brought into this situation think about the noise that's being complained about? Because the person who's complaining really is they're not being necessarily being objective about it. So the test is do we how we measure it from that outside person. In this particular case, which also dealt with the strata setting, the court said there must be a certain amount of give and take between neighbors. And this ties back to that character of the neighborhood comment that I made on the previous couple of slides, was that the court saying in a strata context, you're gonna hear noise, you're gonna have to put up with some noise, there's gonna be some interference. Conversely, that owners have to be careful about making noise. You can't make as much noise as you could if you lived in a single family home or a rural property. Everyone has to adjust what they do and what their experience in the context of the strata setting. And again, the interference has to amount to unreasonable interference and it has to be substantial, intolerable to the ordinary person viewed objectively. So when you're looking at unreasonable noise, particularly if you're a strata council dealing with an unreasonable noise complaint, you're going to look at several factors to help you determine whether or not that noise is unreasonable. So first of which is the nature of the noise. What is it that's being caused? Are we talking about um, conversations that are being heard? Are we talking about music being played loudly, walking, or is someone practicing their electric guitar at full volume at 3 o'clock in the morning? Also, the severity. So, how bad is the interference? Um, how loud is it? How disturbing is it? The duration. So if it's just a few seconds, that's different than if it's for um, several minutes. There's one case I remember I came across where they talked about the noise would occur at stretches of 20 minutes at a time. Also the frequency. Is it every day or is it once in a blue moon or somewhere in between? The intensity, which is very similar to severity, and also the time of day. So again, things which you hear in the middle of the day might not be unreasonable. That same noise, same intensity, etc., heard in the middle of the night would lead or tend towards being um, unreasonable. So it's sort of a bit of a stew. You put everything together, stir it around, look at it, and analyze all of those factors. And again, later in the presentation, we'll talk about how you're looking at the evidence to do that. So, what are some things that could be unreasonable noise? Well, everyday living noises can lead to in the determination that they're intolerable depending on the intensity, duration, and timing. So, one of the most difficult things with noise and strata is a lot of the things being complained about are things that you do day to day living. I'm walking across the floor. I've turned on my television. I get into an argument with my children. All of the dog barks, all of those sort of things. But just because they're normal living doesn't mean that they can't constitute a nuisance. And that's part of what makes this analysis very difficult at times. Also, what is reasonable depends on where the strata is. So, for example, if you're living in a mixed use strata, commercial and residential, uh, noise from the commercial units below may not be considered to be unreasonable because, again, it's that context of the neighborhood. If you're talking about a um, a strata that's entirely residential, that's going to be a different analysis. When you're looking at unreasonable noise, the other thing to take into consideration is that the focus is not on the cause, so what you're doing or what's creating the noise, but what's its effect on the complainant. So this ties again very similar to the uh, normal living noises, everyday living issue. You can't just say, well, just because they're carrying out their day-to-day activities, it's not an unreasonable interference. So we're going to look at what the effect is on the person complaining about the noise, but again, from an objective standpoint. The other issue that often comes up is someone says, "Well, there's no bylaw that says I can't play the drums, or the bylaws allow hardwood flooring." Um, just because there's no bylaw that prohibits or restricts or curtails that activity doesn't mean that it can't amount to unreasonable noise. Uh, and even if the activity is otherwise lawful, it can amount to a nuisance. So the last case I've cited is actually not a strata case. It shows up in a lot of the CRT decisions, but it dealt with a heat pump between two single family homes. And in the end, the court found that the operation of the heat pump was amounted to a nuisance because of the level of noise, but it was an otherwise lawful activity because heat pumps were allowed in that municipality. It was properly installed, etc. And some things that aren't unreasonable um, and I thought about finding specific examples, but there's just so many of them. So I thought we'd stick again to general principles. Um, from the cases. One of them is in a multifamily living situation, you're going to have to tolerate a certain amount of intrusive noise. So just because someone hears their neighbor doesn't mean that the noise is unreasonable. So there's not an expectation of absolute quiet in a multifamily dwelling situation. You are going to hear people that in and of itself does not amount to the noise being unreasonable. One of the other issues that I often run into is older buildings are simply louder than newer buildings, given both changes in construction and just age. And that's often a difficult thing to deal with and factor in. Um, Again, you don't just say, well, it's an older building and whatever noise you hear, and that's too bad. But that needs to be factored in somewhere in that an older building, you will hear more. At some point, though, it does amount to a nuisance or unreasonable interference. Where that is depends on all the factors of the case and the construction of the building. But this case, ULIS at least recognized that there will be some louder or more noise heard in an older building than a newer building. Uh, these two cases sort of reiterate the same point as earlier. Annoying sounds do not automatically equate to unreasonable noise. So just because I don't like what I hear coming from next door doesn't automatically mean that it's unreasonable. It could very well be unreasonable. Again, going back to that test about intensity, severity, frequency, duration, time of day, all of those sort of things. But simply because I'm annoyed by something doesn't mean that it amounts to unreasonable noise. And so again, because everyone lives in a strata next to and close to each other, you're going to hear that. The CRT has recognized that in and of itself does not amount to the noise being unreasonable. And so I thought I would look at just a case study. I chose this one because this is what I love about Strata. You get some very weird and wonderful situations. This is a very recent CRT decision. I think it came out just at the beginning of the week. So the issue was Mr. Kong, the owner of the unit, had dance classes and jazz band practices every Monday and Thursday evening. So this was not a case of the usual. I hear my neighbor walking. I hear them when they go to the bathroom. Their dog barks. He was having dance and jazz band classes. There was evidence of people carrying large instruments into the Strata building. When I read that, for some reason, I just had in my mind a vision of someone in the parking lot carrying a tuba, um, which seemed appropriate for this case. And then the poor owner below complained that his ceiling shook every time that they were practicing. The owner, in his defense, argued that this was a reasonable use of the unit because jazz band and dance class ended by 10 p.m. Every day. So in his mind, apparently it was appropriate to do that so long as it didn't go past 10 p.m. We weren't practicing jazz at 2 o'clock in the morning. He also was very either thoughtful or strategic. He said he only invited experienced dancers who knew how to tread lightly because beginners stomp too much, and that would be too much for his neighbors. So his defense was none of what I was doing was unreasonable, and the Strata should not have fined me. The Strata collected the following evidence. It had numerous videos of the noise filmed from, I think, the unit below. It also had audio recordings of the guests saying, that they were coming to attend dance class or band practice. The unit below kept some noise logs, dates, times, what happened. And then they had witness statements from third parties who attended the unit below and said, this is ridiculous. The CRT agreed with the Strata uh, and found that a reasonable person would not consider an apartment in a four-story residential building to be an appropriate place for band and jazz practices, which I would have thought would have been obvious to all. But there you go, the CRT has agreed with that. So this is an example of, perhaps an extreme example, but an example of the noise complaints and how they play out and how they can be dealt with. So in the end, the CRT held that the fines that were imposed against Mr. Kong were valid because he had created unreasonable noise and a nuisance. I wanted to talk a little bit also now about flooring, because this is one of the issues that comes up an awful lot with respect to noise complaints. It comes up in terms of drafting bylaws and giving permission, uh, and it can be one of the big issues to deal with in strata noise complaints. And it happens more because hard surface flooring is very popular for a number of reasons. Uh, and what I want, and I'm going to put on my armchair acoustical engineer hat for a moment. One of the things that I've noticed is it's the ratings and what's being required of the flooring underlay is very important to get that right because there's a few CRT decisions that deal with this and how you assess the flooring ratings and how you assess whether those things have been met. So there's a number of different ratings that are used. The most common is impact isolation class or IIC, and that deals with sounds generated by something impacting the structure, basically footsteps. There's STC ratings, airborne sounds like walls, floors, or things that are coming through walls and floors like voices or TV. Those two I find are often very similar in what their ratings are. Um, there's also a delta IIC, which deals with the impact of sound isolation provided by just the flooring and the underlay combination. And just mark that one because in a moment I'm going to illustrate why that may be the better one to use sometimes. Uh, there's a new HIIC rating, which is very similar to the IIC, just it looks at a particular range of sounds. And then there is the apparent impact class isolation, which is basically the field performance. So when you put the whole flooring assembly together, the underlay, the hard surface flooring, the subfloor, etc. What rating are you achieving in the field? So that's also one that um, you might want to mark as a potential to use for bylaws. The reason they all matter is because they all provide very different things. And so all the flooring products have different ratings. And you'll see here, this is just a little excerpt from an information sheet from a flooring product or an underlay product. And you'll see all the different ratings. But the IIC ratings, well, all of them, but this is where you sometimes run into problems with particular products, is um, they are assessed on an 8-inch concrete slab with suspended ceiling and isolated floor. So you'll see there an IIC rating of up to 72. Well, that means the product will achieve an IIC at 72 based on an 8-inch concrete floor with suspended ceiling and isolated subfloor, which is not your typical strata construction. So sometimes what you're using as a rating is not going to achieve that in the field. It can still be used as a benchmark, but it's really important, I think, to understand what it is that you are asking people or the standard to meet, because as we'll see in a couple of cases, the two don't always line up. In the Ross case, the bylaw required that the acoustical underlay have an IIC rating of 72. The underlay that was used, in fact, had an IIC rating of 83. However, the strata was still getting noise complaints. There was still noise from below. The strata tried to take the position that, well, look, they didn't put in proper underlay because we're not achieving uh, the IIC rating of 72 in the field. And the CRT said, well, no, the bylaw didn't require that. It just required it to be rated for 72. It didn't actually have to achieve a 72 AIIC rating. And I don't know whether that's actually achievable. That's the extent of my engineering knowledge. But this is an example of understanding what you're requiring in the bylaw. Because if you're requiring the product to be rated for 72, it may not actually achieve that in real life when installed in the unit. Nonetheless, it may still be worth putting because that's a high standard. You're getting the best you can, but it may not actually achieve that, and you can't say that the person breached the bylaw because it doesn't achieve that. It was rated; they met the requirements of the bylaw. Lucas is similar, but their bylaw required an AIIC rating of 65. So when you put everything together, went out and measured it, you needed to get a 65 rating. The flooring underlay had an IIC of 72, and the owner said, "Well, look, it's got 72. That's more than 65. It's got to be good." CRT found that the owner was in breach of the bylaw because the acoustical report the Strata got in the end of the day measured the AIIC rating at 43. So it fell below what the bylaw required. The owner was in breach. So this is just a couple examples of how those different ratings play in terms of bylaw enforcement. I don't know if any is right or wrong. I prefer the AIIC rating. I think is more practical. But if you're crafting a bylaw to deal with flooring and all of these ratings, I think it's very important to understand what they mean and what that means when you're requiring it in terms of noise enforcement and noise issues down the road. Just fixing the flooring problem. So if someone has installed flooring and it is creating a problem, the Strata has the power to require it to be removed. So this ties back to the issue of just because you can do something doesn't mean that it can't equate to unreasonable noise. So you could have installed the flooring with permission with the product IIC rating of 72, you could still be creating or found to be creating unreasonable noise based on what's coming through to the unit below. The Bobiash decision, the CRT said the strata could still require the owner to remove the flooring as part of stopping the unreasonable noise. So the owner wasn't safe just because they had done all the things right with the flooring. Lucas, which was one of the examples we looked at earlier, there the CRT ordered the owner to replace the flooring, not solely because it didn't meet the AIIC reading, but also because of the creation of unreasonable noise. So those are a couple of ways of dealing with the flooring issues. If you've got noise that's being created, there is the ability to have the flooring changed out and replaced with carpet or something better. There's other enforcement remedies, and we'll talk about those at the end, but those are two that deal specifically with flooring. So one of the things that plays into noise is the duty to investigate, and this is probably where most councils sigh or want to pretend it doesn't exist because it's very difficult when it comes to noise. Um, or can be difficult. I didn't say it's always difficult. So Strata has a duty under the Act to enforce the bylaws, and several decisions have said that includes a duty to objectively investigate allegations of bylaw infractions such as noise complaints. So when the Strata gets a noise complaint, it has to investigate that. And that could be, we'll talk in a couple of minutes about what that looks like. It could be making some inquiries. It could go as far as doing repeated acoustical tests. Uh, but there is that duty that exists. The duty is the same regardless of who's complaining, whether it's an owner or a tenant. You can't say to a tenant, "Well, you're just a tenant. We don't have to deal with this." So that duty exists across the board. Part of the duty to investigate is you cannot dismiss the complaint as a dispute between neighbors. So I often hear this from councils. Well, it's just between neighbors. I don't want to deal with it. Not our issue. Unfortunately, in the strata context, it is. The CRT has very clearly said that where there's a breach of the bylaws, which this noise dispute between the neighbors is, that's a strata matter. So strata can't just dismiss it as something between neighbors. You also can't just presume it's ordinary living noise and say we're not going to deal with it. Both of those things conclusions could be reached later, but you have to investigate. So you may determine at the end of the day that there is no unreasonable noise, just owner below is getting mad every time they hear a sound from owner above, and owner above's trying to do their best. But you can't make that decision off the bat. Formal testing, as I said, is not always necessary. So this case, Hirchin, um, in the CRT said that Strata conducted a sufficient investigation by considering the complaints and the responses. So it received the noise complaint, wrote to the owner above under section 135, gave them an opportunity to respond, consider what their response was. Spoke to other residents. So this is not always helpful if it's noise transference above and below, but if it's things like music, loud conversations, arguments, etc. You can talk to people around and say, "Hey, have you heard this?" Um, they also considered whether the noise could be from other sources. So in this particular case, it wasn't very clear exactly where the noise was coming from. They also reviewed and considered the noise recordings made by the owner, and then they issued some violation notices. So they found that some of the instances were unreasonable. So that's not a very difficult uh, set of things to do, but it just shows you what was considered to be or could be considered to be a good investigation. Sometimes, though, you have to actually physically go into the unit. So often, council members will end up conducting in-suite investigations, and this again is particularly with respect to noise coming from hard surface floorings. So you'll have a couple council members above, couple below. The people upstairs will walk around, drop things on the floor. The council members below will kind of assess whether that is unreasonable or not. The view being that the council members are objective, reasonable people brought into that circumstance. So sometimes that test can be um, sufficient. It's also not necessary to attend while the noise is occurring. Sometimes that's best, but I find a lot of times noise complaints, you don't, well, first of all, you don't always know when they're going to occur. Sometimes we're talking about noise at 2 a.m. in the morning, and there's very few council members willing to be woken up at 2 a.m. in the morning and run 3 floors down to listen to noise. Um, if that could be done, that's great, but it's not a necessity. Sometimes, though, expert evidence is required, not only to determine the source, but also the severity of the noise. So, acoustical testing, having in acoustical engineers, sometimes they can determine what can be done to mitigate the noise. Um, Further investigation can be required. So in the Dale case, the CRT actually ordered the Strata to undertake further investigation into the level and frequency of the noise, including further testing. Um, and so Stratas don't always need to wait for the CRT to do that or order that. It could be obvious in the situation that we need to do more here. We haven't got to the bottom. The other evidence that we have doesn't help us make a decision. That duty to initiate formal testing is the strata falls to the strata, not the owner. So if the situation requires there to be some acoustic professional testing, the strata is the one who needs to initiate that. It can't say, well, look, the owner never asked. Again, the duty to investigate encompasses taking steps like that. Sometimes multiple tests may be necessary, and you also can't stop investigating until the source of the nuisance is found. So that particular case quoted the NW 2265, I believe, dealt with smoking, but the principles are the same. If you've got noise coming from somewhere and you can't find it, maybe it's a banging, knocking sound. Strata just can't go, well, we kind of looked around, didn't find it. You have to keep going. Usually, and thankfully, those cases are few and far between. Investigations, of course, requires gaining access to units, so that could be a very difficult thing if you have an uncooperative owner, particularly the one being accused of making the noise. So to gain access, you either have to have the cooperation of the parties, and often it is in everyone's best interest to get to the bottom of this. Sometimes they just don't see it, so it takes a bit of persuading. You could gain access pursuant to a bylaw, but standard bylaw 7 doesn't address investigations or access for investigations of bylaw breaches. So our bylaws that we created, our firm, always have the ability of the strata to enter on 48 hours notice to investigate a bylaw breach. Or you may have to get a CRT order if the owner upstairs isn't cooperating. But that's something certainly to give thought to. How are you going to get in to do these tests? So just looking at a couple of cases about investigations, what to do. So in Dang, it was a fitness studio, mixed use commercial residential building, and Ms. Dang was complaining about the noise. And the CRT found that the Strata had acted reasonably because it asked the studio to turn down the music. A very simple, practical approach. So don't forget that. That can be just talking to people and trying to have some common sense prevail is the place to start. They asked the owner to keep a noise log, and they looked at it. She also completed a diary using the Strata sound meter. They sent council members and the manager to listen to the noise, and they also offered to hire an engineer to conduct professional investigations. So when Ms. Dang took them to the CRT to complain that the Strata wasn't doing enough, the CRT said no, they met their duty, they did all these things, they acted appropriately. The on case is an example of what not to do. And this again had to deal with, was largely about ordinary living noises, and the Strata just simply prejudged it as that. And even when they got the first complaint, said, "Look, this is ordinary living noise. We're not even going to investigate it." They finally got around to it once a CRT claim was filed. The CRT criticized them for having never written to the tenants who were creating the noise, um, and also making a number of just assumptions that didn't have any real basis in the evidence. So the first thing they did is they concluded, well, because they had 60% of the floor area covered with rugs, that meant the noise could not be unreasonable. And the CRT said, well, again, that's not the case. It's you still have to assess it. They concluded that no bylaws were convened, but there was no rational basis for that. The decision talks about the Strata's own noise recordings it eventually did showed that the noise was unreasonable, and it didn't consider each complaint on its merits. And when you read through the case, you get the view that the owner and the Strata were not the best of friends, or I should say, the complaining owner and the Strata were not the best of friends, and that seemed to influence their actions. So again, it's very important not to let that bleed in, to make sure that you do take it seriously, go through the motions. Because at the end, I'm going to highlight a couple cases where the Strata had to pay owners money because they didn't do all this correctly. So proving that noise is unreasonable is probably the most difficult part part of this, or maybe not the most difficult, the most important. At the end of the day, you, whether you're the Strata enforcing a bylaw or an owner trying to prove that the Strata didn't properly enforce it, have to show on a balance of probabilities that the noise is unreasonable. So the balance of probabilities is the standard common law test, basically 51% if you weighed everything up on a scale, that the noise is unreasonable. Uh, the onus is on the person proving it. So if the Strata is going to the CRT for order against an owner, lies with them to prove that the noise is unreasonable. Same if it's the owner complaining the Strata didn't do enough, they have to bring the evidence to prove that the noise is unreasonable and the Strata should have acted. When you're proving noise or assessing noise, the focus again is not on the cause but on the effect. So we're gathering evidence about what the effect of the noise is. Um, Subjective noise complaints of the owner will not do it. So you can't just take the owner's log or complaints alone or as the only evidence because it's subjective. You must objectively substantiate the noise. And we're going to look in a moment about, well, how do you do that? What other factors can you bring in? The subjective, I should also talk about the same thing. You can't just take the owner who's being accused of making noise, take their response in isolation and say, well, it's not unreasonable. Both of those parties, the person complaining and the person being complained about, have a subjective view of the situation. So, ways that you can prove that objectively prove unreasonable noise. So observations from neutral parties, preferably not family and friends. There is one case where the owner presented affidavits from friends she had over from dinner, and the CRT that in that particular case said, "Well, we don't view these as being objective. They're your friends you invited over." And I think it was clear from the subtext they were invited over to have dinner, and listen to the noise. So if you can get evidence from neutral parties, that's better. Council members are fine. Just to comment on that, though, council members doing the testing should consider whether they have any um, connection to either of the parties. So if my best friend is the person complaining, I probably shouldn't be the one who's conducting the test. You can also do decibel readings. They're not always determinative because there's not a lot of good standards out there to compare them to, but they're part of the mix. Certainly, professional reports, sound logs from the complaining owner, but again, those are not sufficient on their own. What sound logs do is they help record the frequency of of it, that's where they're very important. They may not prove that the noise being created is unreasonable. You may need to rely on outside evidence for that, but then you can show the frequency. And then noise recordings. And I say if you can establish they're not manipulated, there was one case where the CRT member questioned whether or not this volume had been adjusted. So it's a little bit, the issue is whether or not these things can be tinkered with. But those are the sort of things you're looking at gathering if you're going to go forward and prove that noise is unreasonable. So as you're going through assessing it, you'll want to be gathering and recording that evidence. Decibel readings are, as I mentioned, helpful, but not necessarily always determinative. There is no requirement that a noise reach a certain level to be unreasonable. It's again part of the mix, but it's not a bright line test. Objective standards, I've always found can be hard to come by. There is a WHO standard out there, but it only applies to nighttime noise within a building. There's no equivalent for daytime noise. So that again is difficult to use as determinative. But there are always comparisons for certain things, certain activities at certain decibel levels. So if I'm getting in, 80 decibel level of noise in the unit, and that's comparable to standing next to an operating dump truck, obviously that's going to be unreasonable. So we'll move now to talking about remedies. So you've gone through, as a council at least, you've gone through receiving the complaint, you've investigated the complaint, you've assessed it in light of the case law, you've assessed it in light of the evidence, and you've reached your conclusion that there is, in fact, unreasonable noise being created. What are we going to do about that? What are your options? So there are a few. There is, of course, imposing a fine, remedying the contravention. You can get an order from the CRT that the owner stop making noise, and there are some certain circumstances you can evict the people involved. And we'll take a couple of minutes just to look at each of those and how they can be employed in dealing with noise. Start with fines. And the standard bylaws talk about imposing a fine every 7 days for a continuing contravention. And this is often an issue that arises with respect to noise complaints. They're not treated properly. They're treated as continuing contraventions when in fact they're not. And the Grabarczyk case dealt with that. It actually would make a very interesting example of the odd things that happen. Ms. Grabarczyk, just as an aside, the noise complaints were because she would wash her dishes in her bathtub in the middle of the night. It was one of the things I remember from that case. Um, but why I've cited it here is the court said when you're dealing with noise, each incident is a separate breach of the bylaw because there is a discrete start and stop. So if I make noise tonight and then I make noise tomorrow night and even the night after, it's continuing in the sense that it's repeated, but they're each distinct individual incidents for which a fine can be imposed and for which notice has to be given when you're sending out that Section 135 letter. So just because they happen all the time doesn't make them continuing. So an example of a continuing contravention, just so it's in context, is if I bring a dog into a building and I'm not allowed to have a dog. As long as the dog is there, it's a single breach. I can be fined every 7 days. Noise has to be dealt with on a per incident basis. Um, and that ties into the bottom point on the slide, section 135. The Court of Appeal said very clearly you have to strictly comply with 135. One of the things before you're imposing a fine is to give particulars or the details of the offenses. So when we're talking about noise, what you're not doing is saying we got complaints that you're making noise all the time. You have to actually basically take that log, put it into the letter. Noise, you made noise at 10 o'clock on Tuesday night doing the following. And duration if you've got that. You don't need to send a separate letter for every incident. You can save them up and then do them as a schedule, but you have to identify each incident. Um, which then allows you, if you find there to be a breach, that you can fine for each incident. Uh, However, you can only impose one fine for each incident. So this ties back to bylaw 3.1. The noise created may be a nuisance. It may also be unreasonable noise, and it may also be unreasonable interference. You can't ding the person for three fines for the same incident. Pick one and fine them only for one of those. Section 133 allows you to remedy the contravention of the bylaw by doing work on or to a strata lot and charge those costs back. So, in theory, the strata could go in and remove problematic flooring or take other steps that would be necessary to reduce or eliminate the noise. And as you saw when we looked at the flooring cases, there's some support for that in the case law. Um, 133, just a side note, before you charge any of the costs back, you have to comply with 135, give them notice of the breach of the contravention, etc. So make sure that's done. Uh, Also consider the fact that if you're spending money, you're going to have to go recover it. So exercise this option with a bit of caution. Uh, you, if you've tried fines and that's not working and the owner continues to make noise, then the strata can go to the Civil Resolution Tribunal and it can ask them for an order. So, under the Civil Resolution Tribunal Act, it can order an owner to do something or to refrain from doing something. So, those are your orders. Stop making noise, stop pounding on the wall, all whatever it happens to be. That order, once if it's made, can then be filed in the BC Supreme Court. It becomes an order of the courts if the owner doesn't comply with it and stop making the noise or do what they've been ordered to do. Then they are in contempt, and there are remedies for that include fines. Um, Jailing, and I know there's lots of councils that would love to be able to jail the problematic owners, um, and or ultimately, we've seen in a minute, orders that owners leave or sell and leave. And so remedies, there is no direct remedy to evict an owner. You have to kind of go through a few steps. So pre-CRT, that would have been under Section 173 of the Strata Property Act. The court can order an owner to stop contravening the bylaws, and it can also make orders necessary to give effect to that. So the Jordison series of cases dealt with an owner and her son whose behavior was so bad and disturbed so many of the neighbors that the court eventually ordered them to leave. So it was a two-step process. An order that they stopped doing that. When they didn't, then the court said, well, it's clear you don't want to live by the bylaws, so the strata has the right to sell the unit. Jordison's, you have to get out. Um, the CRT doesn't have that authority, but if you get the order, then you can go through the contempt process, and then the U decision is an example of a case where an owner was eventually ordered to sell and leave the strata because they didn't comply with a CRT order. Um, so you can get there if it's bad enough, and certainly courts are not going to be likely to order owners to move unless it's the most severe of situations. So I always try and temper a council's expectations with that when we discuss about evicting owners. Strata Property Act does provide an option for evicting tenants. So you can use the residential tenancy process notice to end tenancy to do that. And when I say you, that's the Strata Corporation. But it's very limited. So it must be for a repeated and continuing contravention. So a one-time incident doesn't cut it. Of a reasonable and significant bylaw or rule. So I think bylaw that deals with noise would fall within that. Certainly, if you're relying on the standard bylaws, it would. The legislature is presumed to be reasonable. So if they enacted it, It's got to be that seriously interferes with another person's use and enjoyment of the strata lot. So again, it's that test, not just that it bothers me, just it's annoying. You have to reach that level where things are bad enough or severe enough that you could then invoke this provision, serve the notice to end tenancy, and work towards getting the tenant out. So certainly noise activities would fall within that again if they reach the test of serious interference, which in this case would be very similar to what we looked at with respect to the nuisance. Um, Also recovering of costs. So Strata should always consider this. So part of the duty to investigate may require you incurring costs. Also enforcing the bylaws, there's going to be some legal fees. If the strata wants to recover those from the offending owner, it needs to have bylaws in place to do so. If not, then those are costs that are simply going to be borne, particularly the legal fees borne by the ownership as a whole. So if your bylaws don't have provisions like that, you should consider getting those in place. Lastly, just rounding off, um, there's consequences to the strata if it doesn't act in dealing with noise complaints properly. So you'll see from all these cases, the strata was ordered to pay money of various ranges from 1,500 to 5,000 for not properly investigating or not adequately enforcing its bylaws. So the strata was still ordered to do things to meet those duties, but because the owner had suffered uh, during a period where nothing was being done, there were some consequences for the stratas for their failure to do so. So that should be at least some motivation for councils to make sure that when they are investigating, they're making sure they put a good effort into it. Not only because that's their duty, but there could be some dollars and cents costs down the end of the line. Uh, so just before we move to questions, just sort of a summary. I appreciate that that was a lot to take in an hour, and as I said, there's sort of a high level. What I've hopefully given you is a framework for going into and dealing with all of these situations, right from drafting the bylaws to enforcing them. Each situation is going to be unique, so it sort of does require Strata looking at that within these various parameters, but the facts before them. And certainly, plug for all the lawyers out there. If in doubt, you can always get legal advice with respect to not only your duties, but also whether your assessment of reasonableness is correct or not.
I'm just going to say there's a lot of questions here, Shawn, where people are giving very specific circumstances and asking you, is this unreasonable? Can you just cycle back to like what information would someone give a lawyer to help you determine or give advice on a case about
Yeah,
whether something's unreasonable or not?
Yeah, so if we were assessing whether something's unreasonable, we're going to first of all start with the Strata's bylaws. So do you have the standard bylaws? Do you have something different? If we're talking about flooring, like what does your flooring bylaw say and require? We're also going to look at complaints from the owner. Um, Responses from the accused owner, any other investigations that Strata's done. So it could be they've done the noise test with the Strata noise test. They've talked to other neighbors. So if you're going to ask a lawyer, gather the information first, then it can be assessed because it's really all based on the facts, and that's why these cases are difficult to deal with because one fact that goes one way could make it unreasonable. If that fact didn't exist, then it might not be unreasonable. But those are the things that I would want to see if a client came to me to make that assessment. Then we're going to look at all that against the case law and come
Right.
up with
So a
our
lot
answer.
of these questions, they haven't told us the frequency, the severity, all of those points that you said are, I'm assuming
Yeah,
meant the facts of
yeah,
each
yeah.
case.
And I think that comes back to the Chan decision where it's not the cause of the noise, it's the impact because I could do something, I could stomp around, once, and that's not going to amount to a nuisance. Or just because I hear my neighbor's TV once doesn't mean it's a nuisance. Their dog barks. Um, so it's not looking at the source. It's really looking at the impact.
Right.
Um,
So
eh,
when we've got questions here, you're going to see there's one about power tools. There's one about having a washing machine run at night. These all come back to what you just said about the facts and the impact.
Yeah. So tools, like for example, if I was drilling, putting something up, once and it's never happened again, and it was 10 minutes on a Saturday afternoon, that's probably not going to be unreasonable. If I came home every night from my job at 1 a.m. and started putting together my IKEA furniture for 2 weeks, that probably would be. Um, I mean, I think that's why I chose the Kong case because it was just so outrageous, but it's a great example. Like jazz band practice, no matter what way you slice it, is never going to be a reasonable use. Um,
Yeah.
and so a lot of these things could be reasonable. They could not, depending on what they are.
Right. If walking noise from the unit above is the source of the complaint, what steps should the lower unit be taking to make a record of those noise incidents with the goal of creating an evidentiary basis proving the noise rises to the level of unreasonable nuisance? I know this is just one of many questions, but we see so many cases about
Yeah,
walking noise.
yeah. Yeah, it was. Well, I think I told you before when we were doing our test earlier. I had an acoustical engineer years ago tell me just don't put hardwood flooring in, um, which I guess is an answer to solving the problem, but it's not the decorative style du jour. Where you've got it though, and recording, so a detailed log like date, time, what you're experiencing. Probably the more detailed, the better. Like it doesn't have to be an essay about every incident, but if you put um, Saturday 11:30 p.m. noise, that's not gonna be helpful. Saturday 11:30 p.m. Stomping lasted 5 minutes. Pictures on the bookshelf bouncing. Like the more detail, the better. You could do we've all got our phones next to us with us or within arm's length. Just do a video recording to go with it. Again, that's not determinative, but it's part of the mix. The problem is that if we don't have enough info, we can't enforce it. And helping counsel, if you're the owner complaining, you've got to help counsel prove your case, I guess, if I could put it that way. They need the ammunition and evidence to deal with it.
Take a CRT claim against the Strata Corporation over a noise issue. What do you actually
Oh, as an owner who says the strata's not
not
doing,
enforcing the noise bylaws?
yeah, I mean, you're generally asking for an order that the strata would enforce its bylaws, carry out investigations. Usually, it's framed as carrying out an investigation, but you'd be framing back to section 123 of the CRTA. This CRT can order a party to do something. So you're going to be asking for the strata to be ordered to take certain steps. You may throw in the money, if you're there, ask for it. It doesn't cost you more to ask for more, but you would be asking for the strata to be told to do certain things. So there was one file now that just comes to mind. At our office, the strata was actually ordered to undertake noise testing because they hadn't dealt with the owner's complaint. So the CRT said, "Well, you need to go do some noise testing, and then figure out whether it's unreasonable or not."
Right. So as a strata council, as you said, don't drag your heels, do
Yeah,
something because nobody's going to be happy that the strata has to pay an award to an
yeah,
owner.
yeah.
over something like this.
Yeah, and exactly don't ignore it because it can end up we've had cases where again the stratas haven't dealt with it, and all of a sudden then we're in a litigation situation and we're spending thousands of dollars on legal fees arguing over it. Like, you're better off to spend that on the acoustical engineers and get to the bottom of it. Um, these are difficult situations for councils to deal with, but ignoring them doesn't make it. You're like, the case law is pretty clear. You have to deal with it.
Right. Yeah.
So
Thank you so much, Shawn, for this webinar, and thank you to everyone who joined us today.